Hey folks, I want to take an opportunity to dispel a few myths that are out there about family law during this coronavirus quarantine. But before I do that, let me say this. Google is not your friend, okay? I get calls from clients, past clients, current clients saying, well, I've Googled this issue and this is what it said. Google is not your friend. Your lawyer is your friend. And if you don't have a lawyer, you need to consult with a lawyer, a family lawyer, to find out the facts and truths. Don't go to Google. The other thing is there's been news reports out from the local stations, and they've had lawyers from various firms. There's a lot of misinformation that was given out. There was a lot of things that have changed since then. So even those news reports, don't pay attention to them. Consult with your lawyer. All right, one of the myths that is out there is I don't have to exchange the kids with my ex-spouse because of the social distancing. That is absolutely false. As we've said in other videos, the trial courts across the state, as well as the Supreme Court of Texas, have said that you should follow the plain language of the order and you should go by the regular school calendar for which you are zoned. So what that means is that if a parent is to have the first, third, and fifth weekends, they still get those weekends. They still get Thursdays during the week, and they get them exactly as they would have them based on the school calendar. You cannot withhold the children just because of this social distancing order. Okay, that is a myth. What if I've heard also that my child support stops because I can't go to work and I'm quarantined, and therefore that relieves me of any legal obligation to pay my child support. That is a myth. You must still pay your child support based on the underlying order. Now, we've talked about in other videos what happens if you can't pay that, so I would refer you to that. But it is a myth that there is a legal estoppel stating that you do not have to pay your child support. Okay, because you do. One other thing that I want to address is that there's a myth that all the courts are closed down, so I have absolutely no remedy, even if it's an emergency. That's not true. The courts are hearing essential cases. So let's say that there is family violence going on and you want to file a protective order. You absolutely can file the protective order and get into court and have that heard. Do not put yourself in a dangerous position because you believe that nothing can be heard in court. That's not true. Additionally, things like writs of habeas can be filed with the courts and also get immediate action. It also doesn't stop you from filing other actions. You can file an original petition for divorce. Probably aren't going to get temporary orders, but at least you've got that on file and the 60 days start to run. Okay, so you can do that. You can file your modifications. Again, you won't get a temporary orders hearing for a while, but at least those issues are filed. The other good thing about doing that is once the other party is served, you can automatically begin the discovery period. So you don't want to waste time saying or understanding that I can't file anything in court. You absolutely can, and you absolutely should. But look, if you've got any questions, give us a call. We're always here, and we'd be happy to help you. Stay safe.